Hi everybody, we're with Common Law Assent, reading from the Layman's Guide to the English Constitution by Albert Burgess, another chapter. It was quite a comprehensive and extensive book. We had it printed off. I think it's like our 11th part. You can tune into the rest of it. We are on what constitutes a legal and lawful parliament, and we're in the Midlands Air Museum today.
Change of scenery.
Yeah.
Something different.
I used to play a game in the 80s. Was it the 80s or early 90s on my granddad's was it Amstrad? Something like that. It with a blue screen called Harrier. Just used to like, yeah. So it's a good spot. I'll just get on and read this then. Parliament and the common law. What constitutes a legal and lawful parliament? We're very grateful to Albert Burgess for giving us express permission to read out this book. In the beginning, our forefathers set up a parliament as a tripartite agreement. This was done using the common law. The House of Commons have originated all legislation after blackmailing King Henry V, who needed a tax raise. The House of Commons made it conditional on being solely responsible for starting all legislation. So since 1420, all legislation has originated in the House of Commons. It's an interesting one. The legislation is then passed to the House of Lords, who strictly, in accordance with their collective conscience, they approve it, send it back for amendment or reject it. If it receives the House of Lords approval, it is sent to the King as a petition for his approval. Strictly in accordance with his conscience, the King will grant or refuse the royal assent. If the King refuses the assent, he cannot be asked to give his reasons. In 1609, the House of Commons, as part of their power grab, wrote to tell the House of Lords that they were the Knights, Burgesses and Barons of the High Court of Parliament. The House of Lords correctly wrote back saying they would never accept them as barons, and without the House of Lords they were no court at all. In 1667, the House of Commons told the House of Lords, as an extension of their power grab, they could not amend a money bill. A 10-year argument ensued until in 1677 the House of Lords, in a moment of madness, gave way. There is no constitutional justification for this, and it is only a convention with no force of law. This came back to haunt us in 1909 when Asquith's government put forward a budget, part of which would give the common man a pension. The House of Lords believed they could not amend it, and knowing the common man could not afford the extra tax on top of the tax he was already paying, rejected the budget. Asquith told them he was putting a bill forward to remove their right to reject a bill. The House of Lords said they would not pass the bill. Asquith said he would put 500 new peers into the House of Lords who would vote for its abolition if they did not agree to his bill. Blackmail. In another moment of madness, the House of Lords gave way and approved the bill. Now the bill was placed before King Edward VII, who refused the assent on the grounds the bill was unconstitutional and removed a protection from his subjects. Asquith was ordered to go to the country. He and his ministers toured the country, telling the common man those rich lords with their large estates would not let the common man have a pension. The lords felt it was beneath them to tour the country, saying, "Look, boys and girls, the reason we rejected the budget was because we knew you could not afford to pay the extra tax to pay for it." Asquith was returned. The bill was written into the King's speech. When he reached it, he said, "The only reason I am doing this is because my ministers say I have to." But the King could refuse the assent again shortly after. Shortly after this, the King fell ill and died. On coming to the throne, King George V was told by a minister he kept all of his prerogatives, but could not use any of them without the backing of a minister. So in two fell swoops, the House of Commons had neutered the House of Lords and usurped the royal prerogative. So, in 1911, the House of Commons committed 2 acts of treason and Parliament ceased to be legally or lawfully constituted. To overawe the House of Lords' right to conduct their own business their own way constitutes treason contrary to Section 3 of the 1848 Treason Felony Act. To usurp the royal prerogative is to imagine the death of the king as a fully sovereign king, contrary to the 1351 Treason Act. As laws can only be made by a legally constituted Parliament, and as it ceased to be legally constituted in 1911 with the 1911 Parliament Act, no legislation since 1911 is lawful and has no force of law. As the royal prerogative was usurped in 1911, and the royal prerogative by common law must be given by the king personally, and as the royal assent has not, according to a report by the House of Commons Library, been given in person by the sovereign since 1854, no legislation since then has the force of law, and Section 3 of the 1848 Treason Felony Act cuts in. No Act of Parliament brought in by breaking the common law rules Parliament was formed by has any legal authority. Parliament cannot alter the common law because it was by the common law that Parliament was formed, so the common law governs the actions of Parliament. As a result, all bills passing through Parliament are required to follow the spirit of the common law. Sir Edward Coke, CJ, ruled Parliament may sometimes pass a law which is repugnant and against common right and reason, or is impossible to perform, in which case the common law will intercede and strike it down. There is another type of higher law, that which is a contract between the king and the subject. These form major parts of our English constitution. These comprise Magna Carta 1215, which King John signed after being confronted by the Estates of England at Runnymede. The Estates of England constitute the Lords Spiritual, the Lords Temporal, and the commonalty of England. Thousands of the freemen of England attended at Runnymede because King John was oppressing them using foreign mercenaries. Magna Carta 1215 was not new law. It was a restatement of existing law. Magna Carta 1215 was no more than King John agreeing to rule us according to our existing law. Magna Carta 1215 states you cannot be fined unless you have been found guilty of an offence in a court of law. Section 3940 applies. The Estates of England were asked to assemble by King Edward III in May 1366, who had had monies demanded by the Pope on justification of a debt to the Pope by King John in 1213, when he surrendered England to the Pope and rented it back as a vassal king to the Pope. The Estates of England ruled England did not belong to the king, to King John. It was not his to give away. John only held England for those who followed on. The monies were not owed because King John broke the law. That's 2 stubs from Stubbs Select Documents of English Constitutional Law, Adams and Stevens Macmillan 1921. Those are references. In light of the above constitutional law, the paying of monies out of this kingdom to foreign powers for any purpose are illegal and constitutes theft from Her Majesty's subjects. Tax monies are only permitted to be raised in this ancient kingdom to fight wars or improve the kingdom for Her Majesty's subjects. Paying monies to the EU or as foreign aid is outside the custom and practice of England for the raising or dispersal of tax monies raised from the Queen's subjects. Parliament are there as advisors to the King, that is their role. England's kings are the supreme governors of England. The King rules, Parliament assists. politicians and peers are subjects of the king. As subjects, they are subject to the rule of the king. The king is not subject to the rule of Parliament. On the 8th of March 1784, after a 20-year running fight with Parliament as to where ultimate sovereignty lay, with the lawfully anointed king or with the elected house, after a speech by William Pitt the younger, in which he asked, is it better to be ruled by one despot than by 350 despots, none of whom can agree? The king won the vote, so by English common law and by parliamentary vote, Queen Elizabeth II is the supreme governor of England, from where all her other titles, preeminences and superiorities flow. Hume and Smollett, History of England, Volume 3, December 1880, page 90 to 92. Hume and Smollett, History of England, Volume 3, December 1880. You can read this. We have got this in our files, this whole document. We were saying we're going to do this in 2 parts. How many minutes has this been?
11 minutes so far.
That's really long, but there's only 2 pages left. Obviously, we stand under Article 61, which has been invoked, by the way. So I've transferred my allegiance from the Crown to the Barons Committee, who invoked Article 61 of the Magna Carta since breaches of the coronation oath, allegedly. But that's where I stand. So just so you know. Okay, the Estates of England met again in January 1689. After King James II had fled with his family to France, having been ruling us outside the rule of English law at the request of Prince William of Orange, a meeting of the Estates of England was called, King James II having prorogued Parliament before he fled to France. Without a Parliament, the Estates of England is the only body capable of taking decisions of national importance. The Estates of England drew up the 1689 Declaration of Rights. This was shown to Prince William and Princess Mary of Orange. They were offered the Crown of England, subject to them accepting the terms of the Declaration of Rights. They accepted the terms the Crown was being offered on. Immediately, King William III called a Parliament, but decided against an immediate election. He appointed the Estates of England as his first Parliament. The first thing they did was put the Declaration into law as the 1689 Bill of Rights. The Declaration and Bill of Rights outlaw excessive fines, that all promises of fines or forfeiture of particular persons are illegal and void. This was a reissue of our existing ancient law. Today, this unlawful assembly, calling itself Parliament, are issuing excessive fines. £1,000 seems to be the figure they have settled upon for the common man. This is clearly excessive when you compare it to his monthly wage. The threats of excessive fines for failing to return a tax assessment form, or not having a TV licence, or a whole series of motoring or other fines are illegal and void. This is particularly odious when you consider that the purported Parliament is not constituted as our constitutional arrangements of a lawfully constituted Parliament demand. Every piece of legislation since 1911 Parliament Act was applied as illegal and pernicious. The question we must ask ourselves, is this ancient kingdom, ruled by the rule of law, have the common and constitutional arrangements and the custom and practice of our Parliament been broken, thus making any decisions made by Parliament void and of no effect?